based on your sales volume over a predetermined threshold. And that's what the landlord's going to ask the tenant to do. So those are the three. We'll get to the next example. Gross, net, percentage. There's no others. There's escalator lease, there's a net, there's index lease, there is ground lease, all types of leases, but these are the three basics. Acquiring ownership interest in real title, in real property in fact, or acquiring title, the overall concept is called alienation. Know the word, alienation. And alienation comes in two general forms: voluntary alienation and involuntary alienation. So alienation is when the owner agreed to alienate themselves from the rights of the property. It's called alienation. The owner agrees to alienate themselves. The owner who won't have those rights, I'm going to give it up by choice, or I'm going to have it taken away from me. I'm not giving it up, but I lose it. And if I'm giving it up by choice, it's called voluntary alienation. And there's only two ways, or three ways, but only two we'll talk about, that one can acquire ownership through voluntary alienation. And the first of the two is by deed. This is voluntary. Put it back. Voluntary. By deed. And the two parties to a deed will be the grantor and the grantee, which you learn in chapter 3. The grantor is the one who is conveying ownership. The grantor is giving ownership. The grantee accepts the ownership. That's called voluntary. Another type of voluntary alienation is by will. That's voluntary. You don't need to leave a will. But when one leaves a will, it's voluntary. And who are the two parties to a will? Anybody? Not a willer and a willie. Those are the two parties to a will. Devisor and a devisee. That's why we have the right to call devise of homestead. When one dies with a will, overrides a will. So, that's voluntary. One does not need to leave a will. If one leaves a will, it's voluntary. If one decides to convey through a deed, one that's voluntary. Then we have concept of involuntary alienation. Adverse possession is involuntary, where one goes and gets ownership through the courts because they were trespassing on the property for a period of time or adversely possessing the property. Then we have, if one dies without a will, you have descent. It's involuntary, where the courts, under the law of descent and distribution, will distribute the estate of the deceased. That's the type of involuntary alienation. Then we have these two governmental powers to take private property for public use. You have the power of eminent domain. And if one dies without a will and there's no legal descendants or legal heirs, the government will take the property under the power of escheat and sell it and keep the money until someone comes and claims it. These are types of involuntary alienation. So there are two more where one can lose the rights to the property or give up the rights. One is called voluntary. It's called a, giving a. So giving a mortgage, class, is what type of alienation? That'd be voluntary. That's when you go and give a mortgage to the lender, telling the lender you can put a lien on the property. Giving a mortgage, that's voluntary. And if one doesn't pay the note, The lender goes to court and asks the court to do what? And foreclosure is what type of alienation? Very good. These are the concepts. A mortgage is voluntary. That's why it's called a voluntary lien. It's voluntary specific. Foreclosure is involuntary. It's not the owner selling the property. It's the court selling the property at the request of the lender, taking away the rights of the owner. Because remember, only two people can sell this property in the state: the owner themselves or the court. Those are the two entities can do so.
You have deed as voluntary. How about if we have a tax deed though?
The tax deed, well, that's, you're not paying your property taxes. That's
But that's not voluntary.
No, it's involuntary. Right, the tax deed sale, that's a type of foreclosure. A foreclosure because you're asking for tax deed, the type of foreclosure. You're foreclosing your property for the taxes itself. It's a type of involuntary alienation. And the document you get a tax deed. Right, it's called a tax deed sale. So adverse possession, a type of involuntary alienation, where the property was possessed by an individual without the landowner's consent. The property is called squatters' rights, the old English law. But English law says if one is going to possess an owner's property and the owner does nothing about it, and a time has expired, a time has passed, they are allowed to go and get ownership, because the allodial system grants the property owner those rights, called your bundle of rights, and if they're not taking care of it and someone else is doing so, they have the right to get ownership. The law says so. That's why old English law says squatters' rights. If you are not taking care of your property and someone else is doing so, well, the law will take it away from that person and give it to the squatter. It's called adverse possession. Keyword possession. Possession is 9/10 of the law. So basically, by that person possessing the property, that have 9/10 of his ownership. They don't have legal ownership. They only have 9/10 of it. So how do I go and get the extra 10%? Well, I have to go to court. Because the saying in law, if you snooze, you lose. You sleep on your rights, you lose your rights. However, the law will not automatically grant that possessor the rights to the property. They have to bring evidence to court to prove they meet the requirements. And the requirements are they must be hostile. But hostile means they're staying there. Judge, I was staying here for a long period of time and nobody's going to take me out. I didn't get any legal document to come and take me out. Nobody's coming to take me out, right? And my possession was open. I have open possession. Everybody knows I'm there. My neighbors knows I'm there. Right? The cops knows I'm there. Everyone knows I'm there. And I'm paying the taxes. The property taxes are on the property. And I'm going to the tax collector's office each year and paying the taxes. And now I'm claiming ownership. Here's my document, a legal claim of ownership. And my legal claim says I'll be here for minimum 7 years. And here's evidence. I'm here for 7 continuous years. And here's my documents to prove I'm here for 7 continuous years. Here's my FP&L bill. Here's my cell phone bill. Here's my voter's registration. Here is my driver's license. Here's all the documents to prove that I was here for minimum 7 years. And everybody knows me. Everybody knows that I'm notorious. Notorious means everybody knows I'm here. The owner knows I'm here, but he should never come to take me out. And what the courts will do, will take the rights of the owner and convey it to the adverse possessor. It's called ownership through adverse possession, or squatters' rights, as we call it in English law. So, it's a type of involuntary alienation when one loses their rights to the property because they weren't taking care of it. As we say in law, if you're sleeping on your rights and someone else is taking care of your property, they have the right to possess it legally and have ownership of it through the courts. Ownership through adverse possession.
What if they can't get like a mortgage to pay for it?
Yeah, no. Mortgage has nothing to do with it. Mortgage between the mortgage owner, mortgagee lender. You still have to pay the note. Taking care of the property. The government, because in the legal system, like we studied, the government doesn't own real property. The government doesn't own real property. Governmental properties are owned by the public. That's what they call public properties. And we stand the tax burden for them. And therefore, for the government to provide all of those services to make we live in society the way we live, they need to build these things for public use. How they build the roads, how they build the airports, how they build the schools, how they build the hospitals, how they build all these things that we enjoy today. Well, that's why the government have this power. It's called the power of eminent domain. That's the power granted to them by law to take private owners' rights for public use. Private owners' rights for public use. And if they find that the owner's property is ideal for what they're going to build, but it has to be for public use, they have the right to take. And the process they go through is called condemnation. And condemnation means they are taking away the rights of the owner. Once they take the rights away, the owner have no right to that property. But they have to pay for those rights. They have to pay fair market value. And if the owner doesn't like the amount they're paying, they can go to court and ask for a condemnation hearing. And the condemnation hearing is for two things. The government have to prove that they need the property, number one, and they're paying fair market value. So they have to prove in court that there is a need for it. That's why the condemnation hearing, the government pays for the legal fees of the owner to sue them in court, right? The best lawsuit an attorney can go and get into, because the attorney bills are paid by the government. So the government basically have to prove that there is a need for it, and they're paying fair market value. And like the process we have right now on the border, that wall they're going to build, well, it's on private property. Some parts are private property. And the people are going to court now. They have a lawsuit right now being hanging around for 5 years, making its way to the Supreme Court. Is this a real need? And they pay me fair market value. Same thing they do. Same thing I had to do, take people to court to get a natural gas pipeline across this state. We had people take us to court and say, hey, is it a need? And I have to prove yes, a need. And I'm paying fair market value. So these are the things that people can do. And we have to pay the person's legal fees. Imagine, paying the person's legal fees to sue us. Good deal for attorneys, right? The power of escheat. Escheat means that if one dies without a will, and there are no linear descendants, legal heirs, property rights just can't be floating around. It has to be with private individuals. So what the government will do, will take the property and sell it to another private individual at an auction, and put the money into the abandoned property fund. Until such time in the future someone comes and claims it. One has to prove that we're entitled to get it. But in the meantime, the money sits there. The property is sold. Because there's no linear descendants or legal heirs that come forward, there's no will. So the property just can't sit there. So the government, under this power, will sell the property to the highest bidder, put the money in the abandoned property fund, until such time in the future somebody comes forward. Yes?
There's any timeline when someone would come and claim the property?
Well, if one dies without a will, it just sits there, right? I don't know the timeline, depends on the government itself. State government has it, right? So the property sits there. And because when we have these announcements, these legal announcements, a person passed away, they are triggers that will occur, right? Hey, this property there's no legal heirs or legal descendants. Nobody's coming forward under the law of descendant distribution, because it'll be legal publication. Right? They'll make an ad in legal publication. This property, no one has died. And what it says that all legal heirs or legal descendants come forward and announce themselves. No one comes forward, property goes themselves. And they advertise the sale long beforehand. Yes?
In condemnation, is the owner paid also?
Yes. You get a fair market value for your property. You have to pay. You don't take it away for free, right? You don't take it away for free. Finally, before we go on a break, when one acquires ownership interest in real property, one needs to give proper legal notice. And there's only two types of notices one can give, and they each carry the same legal validity. One is called constructive, recording documents in the public records, and the other is taking possession by giving actual notice. They each carry the same legal validity. One has no legality over the other. The best proof of evidence for ownership is giving constructive notice. But possession basically is the fastest way of giving notice, taking possession. Because once you take possession, once you own it, then it's very difficult to give it up. So taking possession of the property is giving actual notice, recording documents, giving constructive. And if there are disputes concerning who owns the property, the courts will look who gives notice first, either constructive or actual. The person who gives notice first is the one who will get ownership of the property in the event of a dispute. Okay, class, let's go for a break. I'll see you back here at 10 after 11, and we will continue the review.